Morning everyone. This week I'll be talking about health and safety claims under the Employment Rights Act 1996. You'll have no doubt already seen in the news that there are new strains of coronavirus being identified, and this does raise further concern for businesses in terms of opening and managing workplaces. Now, at least in the short term, as we await the impact of the mass vaccine rollout, the prevalence of the virus does continue to impact the usual running of those workplaces. And today we'll be discussing the Employment Rights Act, in particular sections 44 and 100, which employees may seek to rely on in relation to COVID-19. So specifically, section 44 gives an employee a right not to be subjected to any detriment by any act or failure to act by the employer in circumstances of danger which the employee reasonably believed to be serious and imminent, that he could not have been reasonably expected to avert, and as a result either left work or refused to return to work. So how does this apply to COVID-19? So the risk of serious and imminent danger to health is of course contracting coronavirus whilst at work. So can the employee demonstrate that they were not able to avert the danger? Possibly, if the role requires them to complete tasks and duties which puts them in a position whereby they can't avoid that danger. So if they're required to work closely with colleagues or members of the public and don't feel that adequate safety measures are in place, they may raise this, may argue that there's a deliberate failure to act, and may have protection under the Employment Rights Act. Now, as the rollout of the vaccine programme continues, many employers will be anticipating further gradual opening of the workplaces, updating risk assessments to try and get more staff back to the workplace, hopefully in the coming months. And whilst this will be a welcome change back to normality for some employees, others might still be apprehensive and opposed to such measures, particularly given it's not been confirmed unequivocally that the vaccine prevents transmission of the virus, as well as protecting against illness. So employees in such circumstances where they still believe that there is a risk to their health and safety might try to rely on section 44 to avoid returning to work. And the question is, if they do so, how do you as an employer react to this? Now, whilst the situation will be extremely disruptive to the smooth running of your business if you're aiming to open up your workplace to everybody and you have the odd objection, we must be mindful of this statutory right for the employee and respond accordingly in each individual circumstance. So we might look at increased PPE, a variation to duties to remove that risk of physical contact, perhaps continuing working from home, varying working hours or staggering those hours. Any solution really to try and encourage the employee back to work and ensure that they feel safe in doing so. Of course, the job retention scheme is still open as well, so we could continue to make use of that either on a full or flexible basis. So if the problems persist with the employee, if they continue to assert that there is serious risk to their health and safety by remaining at work in light of COVID and the measures that the employer has put in place, could we look at our options in terms of termination if there is going to be a long-term capability problem faced because of resistance from the employee? And this brings us on to the second part of the Employment Rights Act, which is relevant. So section 44 gives employees certain rights in terms of the protection of their health and safety. Section 100 states that if an employee is dismissed because of leaving work or refusing to return to work in circumstances where they reasonably believed they were in serious risk of danger, they are entitled not to be met with detriment. So detriment in this case can include dismissal. Now the test that the tribunal would apply includes whether the risk or the fear of risk of contracting COVID-19 does amount to a serious and imminent danger, and further whether the employee reasonably believes they cannot avoid the risk. Now, it's already a legal requirement for employers to put in place a COVID-19 secure environment, and that would be the defence that the employer would raise. So you would say, well, we've done everything we can to ensure that the workplace is safe. any employee's belief in those circumstances that there was serious and imminent danger is unreasonable to sustain. And I suppose that would come down to the test of whether or not risk assessments were in place, secure measures were in place, and the risk to health and safety had really been minimised. One concluding point on that is that there is no case law. So again, we're dealing with very novel areas of law, and the Employment Rights Act was, these provisions were never really intended to apply to the effects of a pandemic. And whilst that area is untested, we can't be certain of how broadly the definition of serious and imminent danger will be taken by the tribunal. So until that is confirmed, we really want to look at communication and cooperation with the employee in trying to find a solution, rather than moving to dismissal if employees really are reluctant to start returning to the workplace. If you're dealing with a similar issue or you want any help on COVID-19 or employment law generally, please feel free to email employmenthub@chadlaw.co.uk or visit the website for more resources, chadwicklawrence.co.uk. Thank you.